Hello students, welcome to Legacy IAS Academy. In today's video, we are going to discuss about the concept of forests. Basically, how do we define forests in India and what is the recent Supreme Court's guideline to the government as far as defining of the forest is concerned. So let us try to understand first of all the background of the issue in light of which we are discussing today's topic. So very recently, the Supreme Court, that is highest court of India, has directed the central government to follow the broad and all-encompassing definition of the forest. Now, what is this broad and all-encompassing definition? We will come to that in the later stages. Second, if we talk about the definition was laid down in the 1996 judgment, which is popularly referred as T.N. Godavarman case or T.N. Godavarman versus Union of India judgment. A three-judge that is led by Chief Justice of India himself, D.Y. Chandrachud. It was this particular bench which has passed the order on petition, the petition that were challenging the amendment that was made by the central government in last year, that is 2023 to the Forest Conservation Act of 1980. In this regard, the modification had substantially diluted the definition of forest and had reduced the ambit of the act. At least that is the allegation that was presented in the petition to the Supreme Court. Now let us try to understand about what is the amendment that was made to the Forest Conservation Act of 1982. So in this regard, if you talk about the amendment made in 2023, the applicability of FCA had been widened by the judgment of Supreme Court in T.N. Godavarman Thirumalpad versus Union of India case. The amendments were necessary as per the statement given by the Union Ministry of Environment, Forest and Climate Change. He said that amendments were necessary because there are a lot of ambiguities in this particular act, and that was specifically created by the judgment given in 1996, and thus due to these judgments and due to these ambiguities, it was necessary for the FCA to be amended so that it can be applicable over all the areas that resemble the dictionary meaning of the forest. And thus, as a remedy, the amendment made the FCA applicable only to notified forest and land rather than having applicability over the entire area, which can be by dictionary can be called as the forest, and that were identified as forest in the government records only. That means, in nutshell, what we can say, government was trying to bring the amendment to the Forest Conservation Act so that its applicability can be limited to a narrow area, to a much more smaller area, rather than over an entire area which can be theoretically referred as forest. So in this regard, if we talk about how Supreme Court has given the definition of forest, so the court has ruled that FCA would apply to all land parcels that were either recorded as forest or which resembled the dictionary meaning of forest. In this regard, it means that the FCA's scope covers all such area which can be statutorily recognized as forest. It does not matter whether this forest area is designated as reserve forest, protected forest or otherwise. That means even unreserved forest will be brought under the definition of the forest, and obviously the Forest Conservation Act will be applicable over there. So the term forest land will not only include forests as understood in the dictionary sense, but it said that also any area recorded as forest in the government record irrespective of ownership. And thus the CJI-led three-judge bench has reaffirmed the same provision, the same principle, saying that the dictionary meaning of forest had been adopted with the court to align with the Parliament's intent behind legislating the FCA in 1980. Now, why the ambit has to be expanded? That is the question here. So first of all, the ambit of the law is not limited to only reserve forest. It bars the unauthorized non-forest use of any forest land. In this context, the Forest Conservation Act, if we talk about this particular act, the term reserve forest is used only in the limited context of dereservation. Now, if you look at the section 2, clause 1 of this particular act, no reserve forest shall cease to be reserved without prior approval from the center. That means clearly a clause on dereservation can only apply to what is reserve forest already. And while the ministry has repeatedly denied any attempt to dilute the FCA, it did in fact drop the most radical amendment as said by the experts that has proposed to strengthen this particular act. And as per this, ministry was considering introducing an enabling provision in the act to keep certain pristine forests showcasing rich ecological values intact for a specific period. Now, obviously, when the question was asked in Supreme Court, government has given argument in support of its reason behind the amendment. And in that case, government has argued that the main reason why amendment was necessary in the FCA is as a means to address the development needs of the forest dwelling tribe. Because if FCA is applicable in a particular area of the forest, obviously development work will be it will be difficult to carry out development activities, carry out development projects. Second, government says that many people who are living traditionally in the forest areas, they are lacking basic amenities such as drinking water, sanitation and all that. So to make sure the basic amenities are available to them, we need to have amendment in the FCA. And third reason that is given is obviously the development of infrastructure, whether it is roadways, whether it is telecom towers, mobile towers, or any other kind of large scale infrastructure necessitates the amendment in the FCA. Otherwise, the entire area will remain protected and development project cannot be approved. Now, this obviously is again a counter argument has been given by the experts, and obviously we talk about the Minister Yadav, Bhupendra Yadav, who is the current minister. He has said today this FCA comes in the way of building even toilets in school for tribal girls. However, the counter argument has been given by the experts, and they have said that this is not indeed true. Basic development needs of tribal communities, on the basis of which government is trying to amend the act, is already covered under the section 3 of the Forest Rights Acts of 2006, and thus it requires the center to divert forest land notwithstanding anything contained in the FCA Act for certain facilities managed by the government. To understand this, basically we have two acts. First is Forest Conservation Act that aims for protection and conservation of the pristine forest areas. At the same time, in 2006, government came up with the Forest Rights Act, and the section 3 of Forest Rights Acts give the government power that if the development is necessary, indeed it is required for the improving the life of the people living in forest areas, notwithstanding anything contained in the FCA Act, government already has this power to divert the forest line for development. So, since government already has this power under Forest Rights Acts, there was indeed no need to amend the Forest Conservation Act as well. So, thus an amendment to the FCA would not have been necessary only to build these facilities as said by the minister, such as schools, dispensaries, hospitals, Anganwadis, ration shops, water pipelines, mine irrigation project, any kind of development project you name, which might be responsible or which might be useful for improving the life of the tribals, it can already be done by using the Forest Rights Acts of 2006 itself. Now, in this regard, we talk about the challenge that was made to the amendment. Briefly, let us try to understand about this as well. So, it was made by the Ashok Kumar Sharma, who is retired Indian Forest Service officers, versus Union of India and others. A group of retired Indian Forest Service officers, also an NGO such as Vanashakti and the Goa Foundation, they were the one who had challenged this amendment by the petition in the Supreme Court, and it is on the basis of this challenge to the amendment, the Supreme Court has recently given the particular judgment. Now, the potential exclusion of 28% of India's forests that lie outside of the recorded forest areas in purview of the FCA Act, that is the main reason why they said that they have to challenge this particular amendment. Similar concerns were raised by the dissenting members of the Joint Parliamentary Committee as well, who was overseeing and overlooking the amendment to the Forest Conservation Act. And thus, pending finalization of the consolidated record of forest land parcels that would have been considered forest under the 1996 judgment could now be used for non-forest purposes without requiring any clearance under the FCA. And that is one of the biggest threat to the conservation of forest that can happen if this particular amendment goes unchecked. At this, the Supreme Court explicitly thus has asked that its 1996 definition of the forest has to be followed until the consolidated record for forest was finalized by the Government of India. That means after this judgment, if you talk about what will happen going forward, so we can say that by March 31, Supreme Court has asked that all the states and union territories of India should submit comprehensive record of forest that is identified by the expert committee that has been constituted as per the 1996 judgment. Following that, by the mid-April, that is April 15th, then the consolidated data taken from the states and union territories will be compiled by the Ministry of Environment, Forest and Climate Change, and then they will have to publish this data on their website. After that, the Supreme Court has said the expert committee are free to expand the protection umbrella to any forest land that is worth protecting under these two particular steps that has to be undertaken. And thus, after doing all this process, by the July 2024, again the court will resume and the matter will be heard for the final disposal about the legality of the amendment and whether it should be quashed or should be retained. So that is all about this particular review. I hope you understood about the recent rationale behind amendment of Forest Conservation Act and the ambiguity regarding how can we define the forests in India and to what extent of forest area or forest cover the Forest Conservation Act can be applied. Thank you very much.